Hello, everyone. I must apologize first for the slight delay because we were running for another conference, the HCCH conference. May I introduce to you our distinguished speaker, Dr. Geraldine Go Ascola is Deputy Secretary General of the Hague Conference on Private International Law, HCCH. Currently, she is head of the HCCH International Commercial, Digital and Financial Law Division with primary responsibility over the normative projects on central bank digital currency, CBDCs, digital assets and tokens, and the digital economy, as well as the HCCH 1985 Trusts and 2006 Securities Convention, and the HCCH 2015 Principles on Choice of Law in International Commercial Contracts. She is also an adjunct professor at the University of Singapore, in addition to her other esteemed academic titles. We are delighted to have the opportunity to host her for today's talk at the IFO, a side event complementing the HCCH conference that took place in Hong Kong over the past 4 days. Without further ado, please join me in welcoming our distinguished speaker, Dr. Go Ascola. The floor is yours, Go. Thank you very much.
I just have to make one. Thank you. Good afternoon, and I must apologize for how late this is starting. Entirely my fault. I'm very good at getting lost, and Dr. Lee was the one who brought me here. But thank you so much as well for joining me. It's lovely to have you. What I will propose today is this. I know we have an hour of time, and the work that we have to perhaps run through seems to be quite broad. So I suggest if Dr. Lee is okay with it, I'm going to give you perhaps a short overview of the thesis that I came to talk to you about, and I'd be happy to take any questions that you might have as well. And perhaps you could have a conversation, because listening to me for an hour is like stabbing yourself with a pencil. It's just really not fun after a bit. So, all right, shall we do that? Do you think you'll be okay there? Yes, excellent. Okay, my name is Jerry Go Escolar. I'm the Deputy Secretary General at the Hague Conference. And what we do there is a whole bunch of work where we split all of the private international law issues, and we have 4 specific aspects that we look at. So the mandate of the organization focuses on the progressive unification of private international law. And when we say private international law, what we're looking at are really just 4 things: the law applicable, questions of jurisdiction, so which is the competent forum, recognition and enforcement of decisions and judgments, and one 4th pillar that we call international cooperation mechanisms. So those are the 4 that we look at. And where I work, we have 3 divisions of work, so 3 portfolios, and I will focus on the one that I'm in charge of today. The one that I'll speak to you about we call the Codify division, and that's the very street name that we gave to the commercial, digital, and financial law division. So Codify, the Codify division. 2 others are family and child protection and transnational litigation and legal cooperation. Now, quite quickly, when we're talking about international organizations today, 2 things come to mind. One, multilateralism in a multipolar world. So we have more and more nation states that have become states. They're now in close to 200 states really on the world. That's very different than how it was 50 years ago. And 2, we're getting more and more into this whole idea of consensus in a world that has quite a lot of multilateral and regional and bilateral cultures that we have to bring together. Now, I was born a public international lawyer. I adore public international law and international organization law. So what's special about private international law is the respect that it has for the legal traditions around the world. So private international law builds the bridges between each of these domestic jurisdictions, telling parties and people which is the law that would apply, which is the court that would have jurisdiction, without ever changing anything that's within those jurisdictions. So we do not touch substantive private law or substantive law of any kind at all. We really just talk about the procedures between these countries. So that's one thing that I think is quite important to keep in mind today. The second thing that might be also interesting is that what we're looking at is why are we doing this work? right? There are lots of things that we think about when we talk about today's world. International peace and security is at the forefront of that. Global commons and how we are or are not taking care of our planet is the other question that we're looking at. So really big questions. So why focus on commercial law? Is it just dollars and cents? Are we just trying to money grab and get to the greatest profit that we can get, the greatest return on investment? Maybe. And some people, of course, will not deny that that's the motivation. And I'm sure a lot of you in this room share something more. You like commercial law because of what it does for people. For you and me, for everybody in this room, everybody outside of this room, it's really the individuals and really the private business operators that we want to have an impact on. And that's what my organization does. That's what private international law does. It's aside from the very big, kind of like questions of global common affairs, we are really now also talking about things that you and I would do. So we go out and we take our phones and we buy something on Taobao, or we buy something on Amazon or something like that. Where does the money go? Can I set up shop on Etsy and sell something that I would like? You could, of course, set up a coin and hope people will invest in it. There are other things that people can do as well. And that's what private international law does. Now, the talk I wanted to focus on access to finance. And I'll tell you why. So I was a little jealous of the other two divisions that my organization has. Family and child protection, that's easy to sell. Everybody loves children, right? I mean, they are really the hope of our society, the future that we have. If you don't like children, then pretend you do. All right, so we all like children, right? And we want to protect children. This is quite important. We want to protect human rights and human dignity. That's an easy thing to sell. Of course, we want to do that. That's very important, and that's a really important piece of work. Transnational litigation. Are we all lawyers here? Yes? Yes. Do I take the silence as yes, we're all lawyers, or I don't want to admit I'm a lawyer? Okay, I'm going to assume you're all lawyers. So if you're lawyers, one of the things you want to do is give people access to justice, which is a fundamental right as well. And so transnational litigation and legal cooperation allows you to have that access to justice, access to your rights, the right to actually say who you are, to protect your own human dignity and your individualism. That's also not difficult to sell. What do we do with commercial law? Commercial law is interesting. It's one of those things where you have contracts, somehow. We try to find financing somewhere that's also good, secure transactions, insolvency. Great and fine, but where is the human element of that? And that's what I wanted to find. And then, of course, we have Agenda 2030. Now, 2030 is just really around the corner. Somehow it's already 2023, and I'm old enough to remember when we're still worrying about the Y2K. You guys are too young. The Y2K bug, when we're going to go from 1999 to 2000, and all the computers across the world are going to crash. That didn't happen. But we're in 2023, and we're less than 7 years away from achieving Agenda 2030 and the 16 United Nations Sustainable Development Goals. Now, when you talk to lawyers, they always focus on SDG 16, which is rule of law through strong institutions. And that's very important. But I put this to you, that commercial law, financial law, is one of the ways to achieve SDG 1, no poverty. And let me tell you why. I'm afraid that Dr. Lee has heard some of this already, but this really is the thesis. How many people do you think around the world are unbanked today? In an 8 billion population across the world, how many are unbanked, don't have banking facilities? Take a guess, just yell it out. How many unbanked in the world? Try it. I'm going to point at Diana. She's going to save me. She knows the answer. She was listening to me. How many unbanked? What do you think? A number, any number, from 0 to 8 billion. Pick a number. It's not hard. 10. Yes? 3. Okay. Somebody else? Anybody else? Or we just go with 3? 4. Okay. 4 unbanked. Thank you. It sounds like a bidding war.
2% in Singapore, 4%.
No, I'm not going to ask Emily any more questions. She knows too much. Okay. 2% in Singapore, 4% in Hong Kong. In Hong Kong and in Singapore, 4% and 2%. 3 billion is a good number. The World Bank thinks that completely unbanked, we have between 1.4 and 1.7 billion in the world. That doesn't sound so bad, right? But that is the population of the People's Republic of China. The number of unbanked in the world is the population of the People's Republic of China, all of it. Think about that. But that also means that of 8 billion, we're talking about almost a quarter of the population of the world are unbanked. What does that mean? It means they have no access to capital. They have no access to financing. There is a lot of financial illiteracy, and that education or the lack of education continues. Now, why is this important? A lot of people learn financial education and literacy from their parents. That's where, especially in Southeast Asia, we found. So the World Bank and the IMF have run all these studies, and they've come to the conclusion that you are likely to be more financial literate if your parents are as well. What does that mean? It means the cycle continues until it can be broken, right? So what is the great leveler? And I believe digital technology might be it. So why? Because digital technology, Google, for example, has all of its goodness and badness, but it does democratize access to information. So if you know where to look on TikTok, on YouTube, you could get an entire master's degree in financial literacy if you really wanted. Of course, you could also get a master's in financial, very bad information. But if you know where to look, you could actually get that. So I think that's that, and that's where the thing is. Now, so why is private international law important? My thesis is this. Across the world, we have 1.4 to 1.7 billion unbanked, let's say 1.5 billion. And the vast majority of that, some close to 90%, are women. When you have a woman-led startup, so where a startup has a board, which is woman-led, there are only 1%, so 1% versus 99% of the chance that they will get financing. All right, so if you have a startup, make sure you have a man on your board, because if you do, you're more likely to get financing. That's awful for me as a woman to hear, but that's the truth. Now, digital technologies allows two things. It allows capital to flow across borders, and allows then a possibility and non-discrimination to allow people to choose to read things first and decide later in terms of whether it's a woman or a man running these things. It allows people to get information across borders, and most importantly, it allows that money to trickle down to cooperatives and collectives. So for example, we're speaking to some of the people in the Philippines where a lot of the cottage industries are run by women. Currency is expensive in the Philippines. Why? It's an archipelago. So same in the Pacific Islands, Indonesia, when you have an archipelago, cash is expensive. So when you go to a cashless society, when it's based on digital money and so on, it's easier to transact, and you move beyond the barter society. You also then open that world to global digital financing. So that's why I think we need to do that. Now, to do that as a lawyer, one of the few things we can contribute is a very robust legal framework. Now, I'm sure you've heard this thing before. We now live in what's called a VUCA world. You know what a VUCA world is? Have you heard this term VUCA? So it's VUCA, and it's a world today which is described as volatile, uncertain, complex, and ambiguous. All right, so things are a bit unstable, things are difficult, you don't know what's going to change, and so on. It's called a VUCA world. And we do. And as lawyers, one of the greatest value add that we can have in society today is to do the opposite, to create stable, certain frameworks which are simple for people to understand, which are clear. And what does that buy us? It buys us basically business efficacy. How do we do that? When we've done a survey across all the 91 members that belong to the Hague Conference, what we found is business operators want business certainty. So they want to know which law is going to apply. In particular, they want freedom of contract. So they want party autonomy, how to choose, how to choose the choice of law, let them choose which forum would apply and so on. But they want to know ahead of time what that choice is. You would too. You would want to tell your clients, the choice of law should be this, or this court should have competence. If a dispute arises, we need to do this process before that process can take place. And that's what I think lawyers can contribute. That exactly is private international law. It helps to find a framework, which is a framework that tells you what law is applicable, which court would have jurisdiction. And once you have that judgment, it's only as good as the paper it's printed on, unless you can recognize and enforce it, especially today when the assets are across borders. So the work that we do, you've probably read the blurb, and some of the work that we're doing at the Hague Conference now focuses a lot on digital technology. And that poses a bit of a challenge because we want to be technology neutral. Why? Because technology moves so quickly that we want to make sure that our work is not immediately obsolete. So what we have is this principle called technology agnosticism or technology neutrality. That's really tough when you're looking at different technologies like DLT, but we don't look at that. So what we do is we look at the application of those technologies and we ask what digital vulnerabilities come up. So aside from human vulnerabilities, what digital vulnerabilities are we dealing with today in this world? And the projects that we do right now focus on that. The first project that we work on is on the private international law implications of central bank digital currencies. All right. And what does that mean? Today, we found that 91% of the world's GDP comes from economies that have either piloted or already have in circulation a digital currency, or a currency that they accept as legal tender in their jurisdiction, but as a crypto asset. El Salvador, for example, with Bitcoin. 91% of the world's GDP today have a system like this, or they're locked in a jurisdiction that has a system like this. How will that work in terms of cross-border payment? What does it mean for intermediaries like MasterCard and SWIFT? Will that change things? And if so, how will it change payment systems? That's what the CBDC's project looked at. And we also did ask the basic question of what is legal tender and what is the future of cash? What law would apply? And if there's a dispute, which court will be competent? The other project that we do is an interesting one, built out of the UNIDROIT project on digital assets and private law. Now, 3 years ago, UNIDROIT received a mandate to speak about, to work in a working group on principles of digital assets and what private law would apply. And in terms of proprietary interests, UNIDROIT passed in May of this year a set of 19 principles dealing with this. And principle 5 of this principle deal with applicable law in a very novel waterfall concept. So it first defines in proprietary issues, these are the things you need to look at to determine which law applies. We sat the HCCH as an observer in that working group for 3 years. And then at the end of that project, we said, there's a bunch of things that you didn't include in your project. So what is beyond the scope of your digital assets? Are tokens also involved in it? What if it's not a proprietary matter? And so now we have a joint project looking at the cross-border holdings and transfers of digital assets and tokens. So we build from principle 5 and see what we can do there. For those of you interested in public international organization law, this is also the first institutional cooperation between UNIDROIT and the HCCH. 2 distinct international organizations with their own working methods and rules, and we're going to merge that together. So that's also quite interesting. Now, that project had its kickoff meeting in June, and then we had a scope paper asking questions about, does banking law apply? What kinds of assets are we talking about? Is it digital assets only? How about digital twins? How about digital triplets? What about soul-bound tokens? Where is the connecting factor? Now, the moment you have something digitized and online, the connecting factor starts to become nebulous, because a lot of our connecting factors traditionally are rooted in geography, so in location. If you cannot pinpoint the location or the identity of the holder, or if there are too many locations, then what rule would you apply? But when we have now the new applications, so soul-bound tokens, for example, Vitalik Buterin in September of 2021 released a white paper saying, well, we can use these tokens almost like country club membership cards, where you earn certain credits, which are linked then to your identity. So you are incentivized to show a location, to show an identity, and that overcomes the pseudonymity that usually accompanies this sort of crypto-based applications. If we have that, do we then go back to the traditional connecting factors? What do we do there? So this project looks at that. We have a third project called Digital Economy, and there we look at the private international implications of data transactions, which is the next big thing, right? So the assets which are worth something today are all data. It is data that is worth something today. When we have those transactions across borders, how do we look at privacy, for example? How do we protect weaker parties? And from there, what law would apply to big data, which is a conglomeration of a lot of data? From there as well, how do we then regulate, or what kind of private law rules would apply for artificial intelligence augmented big data? If I take all of this data and I scrape it across and I drop it into one of these large language models and they look at it, what law would apply? If something goes wrong, which jurisdiction would apply? If I have a decision, how do I apply it to something like this? That's what we look at as well. And the last thing that we look at in the Digital Economy project are metaverses and immersive technologies. So metaverses is now a bad word in the industry, but essentially what we're talking about is technology where you can immerse yourself into, so really augmented meta realities. And what's interesting about this is the non-fungible tokens, which now have some sort of value. And the question is, for example, in an insolvency proceeding, how would you trace these assets? How would you value these assets? And how would you enforce an insolvency-based decision across the border when there's a resolution involving these sorts of assets? So that's what digital economy looks at. Of course, we look at insolvency as a whole, and we also look at intellectual property, which we can't do without this economy. And the last thing that we are focusing on, which really excites me, is this, and this is brand new. So I think you're the third group of people I've spoken to about this. On July the 21st of this year, the United Nations Commission on International Trade Law met in Vienna. They have their usual annual meeting where they talk about their work program. And one of the work program items put forward was that UNCITRAL would start looking at the trade law implications of climate change resilience, mitigation, and adaptation, together with the UN Framework Convention on Climate Change Secretariat. A lot of questions there, but here's the interesting thing from a commercial point of view. Global commons, very important. And what I say does not detract from how important it is to protect the climate, protect our planet, and talk about the global commons, okay? So this is important, let's just acknowledge it. But if commercial factors and commerce and profit can serve as a catalyst or a motivator for us to actually protect our planet, I don't think that's a bad mechanism to leverage. So here's the proposition. We have members, Bolivia, Brazil, who are carbon positive. What does that mean? They make enough so that they have carbon credits in the positive. And there is, of course, as you know, these markets, right? So carbon trading markets and so on. There's the voluntary part of it and there's the compliance part of it. Now, those markets haven't started trading properly. And one of the reasons why is because nobody knows what these tokens are. Are these credits property? Are they intangible property? Can you secure a loan with them? Are they simply a promise? Are they transacted like currency? What is this thing? And the characterization of these things, these carbon credits, will determine then which law would apply. And the moment we can do that, we can trade. Why is that important? Most of these economies that have carbon credit positivity are from the global south. And it provides then these countries with an additional source of revenue, which we hope can also be channeled towards breaking poverty cycles or hopefully doing something good for the planet. Now, I know the first question is going to come, which is all the credit fraud issue. How do we do the ETF system and so on? We don't touch the regulation, nor do we touch criminal law. But what we do is to say what law is applicable, which court would have jurisdiction, and from there, hopefully come up with a system that will allow trading. So we don't have a mandate right now. UNIDROIT is starting work on the private law aspects of voluntary carbon credits. UNCITRAL is starting work on the trade-related aspects of that, but they can't really move there until they know which law is applicable. So under the banner of cooperation, the Hague Conference will start working on these issues under cooperation. And next March, we're going to put forward a proposal to our members that we will start work on applicable law issues for carbon markets. So now, why do all these things matter? What I want to do is then maybe focus on the one basic question that we look at in all of these projects and tie that to access to finance. In all of these projects, the first question that we always ask is, what is the applicable law? Right? So why do we have applicable law? And if we do, then what law would apply? Now, we don't say it is contract law or it's tort law, it's property. We don't do that. What we do is we provide a rule so that the parties involved can choose within certain limitations like public policy, they can choose what law they want to apply. Okay, it does two things then. One, it ensures freedom of contract and party autonomy. So that's important. And two, it creates some sort of a competition between jurisdictions to come up with legal frameworks that actual people and businesses want to use. So it creates this motivation to come up with a market framework, a legal framework that you can actually sell to say, you know what, Hong Kong law would be wonderful for carbon markets for these reasons. And then another jurisdiction say, haha, but you missed this gap. And this gap is the thing that people want to fill, in which case Hong Kong will say, okay, then I'll fill that gap and I'm still better than you. And what does it do? It gets us not to the international minimum standard, but to a pretty reasonable standard that all of us can live with. So that's how private international law contributes to the public international law framework. And from there, it allows the markets to really kickstart trading, cross-border flows of capital, financing, and all these banks and venture capital funds and so on, they want to know that the money is going to come back at some point, hopefully, better with a profit. And if something goes wrong, which law is going to apply and how they're going to sue these buggers and get their money back. That's what they want to know. And that's what this framework gives, a legal certainty, so that investors can know, I will put my money into this and I know that there is some legal protection. That's the work that we do. And in giving that kind of certainty to the people with the cash, it allows cross-border flows of investment, capital, financing, and it trickles all the way down to the cottage industries, to the women who are weaving and making collectives, and they allow these sort of businesses to have a global front. It allows global financial inclusion of our most vulnerable today. I'm going to stop there, and I hope I haven't bored you to tears. I was going to make some slides because it's much interesting to look at slides rather than me. But in the interest of time, I decided not to do that. So I'll stop there and I'll take whatever questions you might have. I hope I've been clear enough. And I thank you very much for your patience with me.
Definitely have been clear enough and probably too much information to digest at one time. Any questions from the audience? May I ask the first question, if just to warm up the audience? My question concerns the adaptability of current laws in light of emerging technologies such as blockchain-based smart contracts at all. As you know, they can be designed to either complement or to escape the law. And so that's for depending on the designer's intent. I also want to describe a little bit about the top-down approach for traditional laws, because as you know, traditional disciplinary governance has often been characterized by the so-called top-down approach, within a centralized hierarchical structure, which may not easily adapt to the new system, which is decentralized, disintermediated, and autonomous, embodied by, say, blockchain technology. So I'm quite curious as to say whether the Hague Conference on Private International Law, your institution, HCCH, provides any regulations, insights, guidance to prevent regulated institutions from circumventing disciplinary governance through these innovative systems. Okay, so yeah, I know it's a very long question. Basically, my question concerns, again, the adaptability of current laws. And as you know, the current laws, when they were created, the legislators and policymakers did not have these technology in mind. Okay, and so because they were created decades ago before all these new technologies have been introduced. And so I use the new technology such as blockchain or blockchain-based smart contracts as example. As you know, smart contracts that can be automatically executed. And so that goes to my question, that is with the technology, which is now being able to design either to, that is a good thing to complement law, or to, that is the bad thing to circumvent the law. So what do international regulators such as the HCCH have in mind? Is there any regulations, guidance, or rules, insights in this regard, how to prevent, avoid circumvention of existing laws? Thank you.
Thank you. That's, I mean, I think you put your finger exactly on the pain points on this whole thing. If I might, I think there are 3 points that I'd like to address. One is technology and the developments and how quickly. The second is this top-down versus a decentralized thing. And the third thing is a circumvention thing, which I'm going to write down before I forget. circumvention, right? So from the first, technological development is a problem because a lot of our conventions take a long time to get done. So at the organization where I'm at, we usually start with an exploratory study. So we get experts in, we start to explore, we start to scope a project. Then we get experts to actually tell us what the issues are. That might go on for a year, it might go on for 10 years. Then we elevate that, if we get to that stage, to a working group stage where we start to write norms with input from governments, so actual states that can sign up to this. And then if that works, it goes to a special commission where the government send their experts. And if that works, it goes to a diplomatic session where diplomatically accredited people come and we try to finish up a convention and sign it. Now, you must have heard on the international plane something called treaty fatigue. So basically countries are sick of treaties. They don't want to sign treaties anymore. They're withdrawing, something called treaty fatigue. I haven't seen that actually happen with our treaties because we're actually getting more and more signatories and ratifications of our instruments. But in particular, we actually have one called the Judgments Convention that took a really long time, but has actually just entered into force on the 1st of September. How do you deal with technological developments? We have this, like I think I mentioned, this idea of technology neutrality, which only works to a certain extent because sometimes you have to take into account technological developments. There's nothing you can do about it. So what we do is focus on applications and what happens beyond the technology. So for example, one of the projects we're looking at is central bank digital currencies, but in this, what it is actually is payment systems. So the moment you take that currency outside of its usual ambient environment and you go into across the border, it's a cross-border payment system problem. And that's a problem that has existed from before. So we look at that. And the first question we ask is, do we already have something that addresses that problem? So we're not going to reinvent the wheel. We're going to look first and see, is there a law? And then does that law still apply? So is there coordinated guidance? Does it still apply? If it does apply, super and great. Maybe we just need some sort of guide to good practice or something like that. But if there's a gap there, then we say, okay, maybe there is normative work to be done there. So that's how we do it, technological agnosticism, which is very difficult.
Sounds like a principle-based approach rather than rule-based approach.
Yeah, so really it's a very principle-based, absolutely. So then the top-down thing, and this is actually something that I think every field is actually grappling with, which is that the international community system dates back to, well, Westphalian times in 1648, right? So this whole state-based idea. We still need states and we still need people with locus or entities with locus with standing to sign up to these treaties. But more and more, we're starting to see that there are these treaties which then have things below them that allow civil society to get involved. So multinational corporations, international NGOs, and so on. And more we're getting these entities in as observers and as experts to sit on our work. Why? One of the worst things that can happen is to create a convention which in principle on the law is the best legal piece of writing you will ever have, and absolutely no politician will sign up to. Why? Because then it seems to prove in customary international law that that standard is not what the international community wants. See, so imagine I say, okay, well, imagine you have a convention where solar power should be monetized, let's say. Okay, I know that's not what you want, but let's just say, okay, let's say we get to a convention that says that. And so we come up with a convention, it's legally watertight, it's wonderful, it is sound, and nobody signs up to it. You could then say, well, if no state signs up to it, obviously this is not international law. So that's actually really quite terrible, aside from the terrible sink of resources that we just put into it. So what do we want? In today's world, with distributed ledger technology, internet, and so on, we want things to be decentralized. We want a whole bunch of things to be autonomous. But the question really is, have we really removed the intermediary? Or is there still this intermediary between you and me and this big international plane? Is the state now the intermediary? Have we really removed that? Because if we have, what is our standing? Where do we stand? And for example, in quite a lot of jurisdictions, when we're talking about proprietary interests, where does that come from? Have you thought about that? Like when you own a piece of property, you own it because the state says you get to own it. So if you buy a piece of land, you have to go to the registry, you have to write it in and so on. And the state says, by rule of the king, queen, or whatever, I give you the proprietary interest in that piece of land. And a lot of times in the proprietary interest, it comes that way. And it's still being used for things like outer space, right? So the argument as to why you can't mine on the moon is because no state is allowed to appropriate things in outer space. And therefore, if you have that issue, then none of us can do it too. That's the argument. Is that true today? And when we create things like digital assets, can that still be true? So what we do is we need that top-down approach because the structure is there and it's kind of difficult to tear it all apart. But we have done at the Hague conference is to get people like the Ethereum Foundation in. So we get Ethereum in, we sit across the table from them, we say, tell me, do you want to be regulated? Is it a good thing? Is it a bad thing? And of course, that raises some questions as well. As you know, I think yesterday, a bunch of Congress people in the United States met with top tech leaders, including Elon Musk, to ask them, shall we govern and regulate artificial intelligence? And all of us are looking at it on the television going, how come he gets to say whether we are regulating? How come he ask me? Why are they asking him? And so the question whether 20 important people can decide this for you. We can, of course, go about it in the DAO way, a very decentralized way, or a different way, but we try to get these people in the room. You had a comment to that, I'll stop.
Yeah, I actually think that it's a very interesting question. That is whether we still need intermediaries. And just seems to me that the retail CBDC, central bank digital currency, would be a good example to talk about this, because take the new project Sailor that you talk about, which only came out. The Hong Kong Monetary Authority actually issued the joint paper only 2 days ago. So taking Project Sailor as an example, it has the central bank operate the retail ledger. So do we still need intermediaries? Yeah, if we no longer need the banks to be in the position to face the retail clients. So there will be an interesting discussion to have. The reason why I single out the new project Sept, is because compared to the previous project that Hong Kong Monetary Authority has, that is Project Aurum. Aurum, actually, if I'm not mistaken, Aurum stands for gold. That is gold in Latin. It had a different design. It had the central bank operate as a wholesale ledger for the EHKD. So you are an expert on this, and you have project on CBDC. So I think CBDC is actually a better example to discuss the role of the financial intermediaries, whether they should reinvent themselves, or whether, we should just, remove them entirely, but at what cost?
Yeah, no, that's a very good question. And I think in some jurisdictions, as you know, some jurisdictions have decided not to have the differentiation between retail and wholesale CBDCs. So they just want to have CBDCs in general. And then we're facing that problem, for example, with Luxembourg and El Salvador, where they do not have a central bank issued currency, but they adopt crypto, for example. So it also happens in certain federal states. So in Switzerland, in the canton of Lugano, you can pay with Bitcoin. You can only do that in Lugano. The rest of Switzerland will tell you, no, we're not going to take that. But Lugano has said we'll accept Bitcoin as legal tender. So what happens with the Swiss franc then? What do we do there? And I think then the overarching question as well is, what is then the point of doing central bank digital currencies when we already have digital banking? So what does it add to the table? And I think a lot of jurisdictions are still grappling with that. How do you remove the intermediary? Should the state still regulate? With all the questions about weaker parties, how do you protect the vulnerable people who get scammed essentially into transferring things?
Or foreigners, children, for example, because children can easily hold cash, coins, but they probably cannot hold the CBDC, retail CBDC. And so in the central bank in Israel, on our way here, I have a discussion with you. They talk about, for example, in Israel, the minimum driving age is 16, and minimum age for opening a bank account is 14. So how about, having children use the CBDC? Should they lower the age lower than 14? Or should they allow children to use the CBDC but put their pocket money, if given from their parents, under the sub-wallet of their parents. So these are very interesting and practical questions to discuss. Also, in the example of foreigners, would you allow foreigners to use CBDC? Will they be afforded the same level of protection as the locals?
Yeah.
So,
No, absolutely. And also one of the other questions actually is, how does it interact with other legal framework that already exists? So I'll give you an example. There's a 1996 Convention on Child Protection, so the protection of children, applicable law and so on across borders. And one of the provisions is that it protects not just children, but their property too. So the idea is to protect children and their property across borders. The definition of children in that convention is 18 and lower. In a lot of jurisdictions is actually lower than that or higher than that. So we have that gap there. But then the question, of course, is if you have these CBDC wallets and you allow children to hold them, where are these assets? So if you have an emancipated child, for example, or a child whose assets need some sort of protection because they're in a vulnerable situation, which jurisdiction protects that wallet once it's a cross-border question? So this is something as well that I think quite a few banks are dealing with. But SEMA is a very interesting project because it also involves the Bank for International Settlements.
yeah.
And I think there, what's really special is that they really look at how it would work in Israel. So it's a project that's tripartite.
Yeah. That's why I mentioned about Bank
Exactly.
of, the central bank in Israel, because it's joint project between Israel,
The Hong Kong Monetary Authority
and BIS.
And BIS, yeah.
Yeah, innovation hub.
Exactly. So then the question is basically between Israel and Hong Kong. When you look at something like CELA, what law would apply? You get to choose, or does the regulator tell you? And then what happens if it's more than two? Between, I think it's Panama and El Salvador, they've already merged, for example, the stock market. So you can, in El Salvador, with El Salvadoran dollars, basically, they also have, El Salvador has its own money, which is also attached to the US dollar. But in El Salvador, because Bitcoin is legal tender, you can buy stocks on the stock exchange in Bitcoin. In Panama, you can't do that yet, and they are pegged to the US dollar. And the US has its own digital USD. So the question is, can you in Panama, using a digital USD, buy a stock on the El Salvadoran stock exchange and then get whatever, and then sell it to get Bitcoin? Is that a way to circumvent? Which then kind of goes to your third question. How do we prevent this sort of circumvention? And I'm sorry, but we don't really have the answers to that. We're still negotiating all of this and questions that are coming up. But I think we also had a conversation about this. The questions are important before we start to create legal frameworks for this and designate which law would apply. We need to consider all of this.
Thank you for thinking that my question was relevant.
More than right on point. Yes.
Yes, thank you.
Thank you so much for the insightful and the informative talk. As I'm finalizing my PhD here at Hong Kong U, I'm also, just because I'm also a fellow at a FGV Real Law School, so I'm basically collaborating with some Brazilian colleagues. We, on a working paper in terms of the central bank digital currency, we're comparing, for example, Brazil and China in terms of the digital payment infrastructure. We realized that there is a big difference between their technological infrastructure. For example, in Brazil, people use PIX, the system for digital payment, but in China, everybody uses WeChat Pay or Alipay, the QR code system, right? So do we have any international legal instruments to facilitate this sort of technological inconsistency across jurisdictions? And yes, but we realize it's super difficult, but then that's probably relevant to my second question. That is the central digital. When we talk about the technological infrastructure of the CBDCs, there is always an issue of digital sovereignty. We cannot standardize this technology infrastructure across borders. So I would like to hear from you about your insights. Thank you.
Thank you. I'm not sure I have a lot of intelligent things to say. The first question, Brazil, for example, PIX is actually quite new. It just came up a while ago, I think, but it's all over Brazil. So it's wonderful. I was just in Rio, actually, in July. sorry, in August, and I was on the beach, and this person was trying to sell me a bikini on the beach. They do that, just walking around bikinis and sell you. And I said, well, I had no real. No worries, do you have pics? You know, so you could actually buy a Coca-Cola on the beach, or buy a bikini on the beach with this pics thing. But pics you can only use in Brazil. So WeChat, that's what the WeChat Pay thing is mostly in China, for example, but you cannot, for example, use pics here and the other way around. And that's one of the issues. We have a lot of options when it comes to nationalized payment systems. When we go to a cross-border thing, we start to run into the SWIFT network or MasterCard or Visa or something, intermediaries. And of course, the whole point of this whole movement is to become disintermediated, to kind of take that away, that power away, and democratize it. But to do that, we need to, firstly, as you say, have a standard system. Now, I understand more and more of these startups are coming up with possible standardization. That was what I suppose Satoshi wanted to begin with. That was the whole idea, to have this Bitcoin thing before the whole environmental thing started. But if you have a system which allows cross-border transactions like this, what law would apply? And then the question is, would a cross-border digital payment system, so a kind of currency that allows it, which is a central bank issued one, become like the US dollar, where people just peg to it as opposed to just using it? You see, and then what are the implications for that? So to your first question, maybe a partial answer. Nationalized payment systems we have. Private international law questions always arise in a cross-border context. And right now, there is no good system. The digital euro might be one thing that will happen, but with the exit of the out of the European Union of the UK, the rest of the countries have a pretty systematized legal framework anyway. So I'm not sure whether the digital euro will help with that. There is also a project that was under consideration in ASEAN, in the Association of Southeast Asian Nations, for the ASEAN unit of currency. I don't know what you want to call it, the ASEANO, I don't know. But, you know, sort of to cut this thing together and to do it digitally. In that case, that will be the interesting test case, because ASEAN is, as you know, a collection of 10 very different jurisdictions. And then that will probably be the test case. So I think that probably is the first, as far as we know, at least. I would encourage you, if you have some time, on the 5th of October, my organization has a conference called Colloquium Online that addresses all of these questions for CBDCs. And we have experts from across the world talking about this. It will go live at 9:30 in the morning, Central European time. So that would be 9, 10, 11, 12, 1, 2 o'clock, no, 2 o'clock, yeah. In Hong Kong time, 2:30. And we're going to release all those videos at one shot. We also have a live panel discussing exactly this issue. Your second question. Yes, thank you. Digital sovereignty. So when you come to a public international law point of view, states trade a bit of sovereignty for some international minimum standard. That's what usually happens. So you go to the UN, states give up a bit of their sovereignty so that they get some sort of minimum standard in return. Private international law doesn't do that. It assumes that every state has its own digital sovereignty, and it just allows the choice of which sovereignty you want to subject yourself to, basically. So it builds that bridge between the two jurisdictions, but it doesn't tell those two jurisdictions what to do. That rises to problems. One, when there's a lack of trust between two jurisdictions, there is no agreement for bilateralization. So what happens is you get two jurisdictions that may sign up to a treaty and put an objection in saying, I don't want the bilateral agreement with this other country because of digital sovereignty. So that's one problem. The other issue, of course, is when you have digital sovereignty, what exactly does that mean today? Because in particular, in a more decentralized system, is it the location of the server? Is it where the information pings? And if so, then it's subject to quite a lot of different digital sovereignty frameworks, which is exactly the opposite of what this was intended to be. So one of the things that we came up against when we did the work for this was this kind of tightrope that you're walking between making it applicable. So people who actually on Solana and Ethereum and all that, they want to have, say, a choice. They want to not be subject to regulation. And on the other hand, this group of states and so on who want digital sovereignty. And the idea is to get them together and see how far we can get on an agreement on how much sovereignty to give up and in return for what. I hope that answers at least part of your question. Thank you for your question.
Yes, please.
Thank you. Following this gentleman's question, I do have a problem. First of all, I'm the LM student in the ADR program here, and this is my first year here. And thank you so much for a fantastic speech and a lecture. And my question is, as you have mentioned, like the transport of digital information as well as personal privacy, which is the personal confidential information across border. So they somehow raise a question, just like some of the countries may very discreet upon the cross-border transportation of personal privacy, and somehow we deem them as within the state's jurisdiction to pose a enforcement action on it. So we can have, like, for example, China and the other countries, that when the privacy of the Chinese national has been cross-border, they may somehow enact some of the actions from the Chinese government. So we can also cross these like ideas, as you have mentioned, that when it comes to the digital sovereignty areas, we may somehow determine the boundary of national sovereignty upon the location of the service. As I think some of the experts in the NATO, such as the Tiny Manual, have mentioned this question, but there's also some of the other idea that the state shall also cross the mere location of the server and to pose its hand to wherever the information of the nationals locates. So that somehow creates a question of extraterritorial law enforcement may somehow be involved in, shall we say, international commercial contracts or something like this. So I wonder if there is any solution or research insight upon the possible state's intervention by means of extraterritorial law enforcement to like transport them their information. Thank you.
That's a very good question. I can try and yes, that's a very good question. And I think that actually is not a new question because, so for example, as you mentioned, the citizens of China would carry their laws with them, with their identity across the border. If you come from certain other jurisdictions, you don't do that. So the moment you cross the border, you're free, you're subject to the other countries' laws, but not to your own anymore. So you do not carry with you your national laws. And this is one of the biggest issues that we're facing. So some people are subject to many more obligations than other people are. And what does that mean? But aside from do you carry more or fewer obligations? In general, there are some obligations on these people. And then the matter of then privacy, right? So it's linked to when you want to carry your laws, you need to identify. So the identification of the user or the identification of the whatever wallet holder, whatever is necessary. But the whole point of this sector was anonymity. So the whole point was not to have your say your title. So you know this wonderful man that has whatever $8 million worth of £8 million worth of Bitcoin in a hard drive somewhere at the bottom of some landfill in the UK. You know, if I go into a landfill and I happen to pick it up, in principle, that's mine, right? I mean, like, because if I have the key, of course. I mean, like, you know, if I have the key, that thing is mine because find the keepers. So how would you link that? And how would that industry react towards now this movement to, I want you to carry the law, and so I want you to be identified? And then in between, because of the soul-bound token issue, there are now incentives for you to be linked to it as well. I mean, so to have that. Now we have a bunch of different, we have a bunch of rules already in place in different jurisdictions that answer that question, the PRIMA rule, the PROPA rule, and so on. And I encourage you, if you're interested, on the website of the ACCH, so it's acch.net, under governance, and you go to the Council on General Affairs and Policy, in preliminary document 4 of 2020, there is Annex A, which explains all of these rules together with the examples in each of the jurisdictions, PROPA, PRIMA, blah, blah, and so on, of which law would apply in these situations, and whether these are considered intermediated or disintermediated. So it's a pretty long annex, but I encourage you, if you're interested, to have a look at it. I can point you directly to the page as well, if you'd like.
You know the ins and outs of your legislation. Yeah, that's amazing. Any other questions? I'm aware that we were slightly late, so being a little bit conscientious, I like to suggest that we extend it for another 6 minutes because we were 6 minutes late. Taking this opportunity, may I ask the second question, because you and we have the common interest of financial inclusion. And I had the pleasure of sharing the stage with Dr. Go yesterday when we both spoke at the HCC conference. We were on the same panel. And there was a very interesting point that you raised, that is the concept of technology neutral approach. Taking Hong Kong Monetary Authority, for example, in regulating virtual banks, Hong Kong Monetary Authority's stance is the same. They want to take the so-called technology neutral approach, implying that whether technology is used or what technology is used by the authorized institutions, which include banks, they do not care because all these authorized institutions, from the regulator's perspective, they should be subject to the same regulatory standards. For example, banking ordinance, which is the banking law in Hong Kong, as well as, the AML-CFT regulations. So this is the so-called technology neutral approach. My question is, would this approach promote financial institutions' deployment of technology? By deployment, it implies that they will have to invest meaningfully in technology. But with this technology in mind, would it promote or discourage financial institutions from making such investment for the purpose of enhancing financial inclusion?
That's a hard question.
Sorry.
I think that's a really good question. And I think that the particular example that first comes to mind is you were very, very aware, of course, in the last, 2-3 years, a whole bunch of wallet holders went bankrupt. And then basically a lot of people lost a lot of money. And so people are being prosecuted today. I don't have to name them, but you know them, right? I mean, you're aware of this? Yes? I hope you haven't lost any money in it. But basically a lot of these wallet holders either disappeared, lost their keys, or it was just fraudulent and these people have just disappeared with it. And I think the reason why that comes to mind is this: a lot of these, so I spoke with quite a few people who deal with this, and one of the ways that they made these crypto assets accessible to the mass majority of people was to put it on technology which is very open source and which is very low tech. Okay, so on the one hand, great, right? Because democratization, as long as you have the basic technology thing, that's fine. On the other hand, all the laws are technology neutral. So you have banking ordinance, you have certain standards you have to meet which are application based rather than technology based. And because technology moves so quickly, there are very few standards on exactly what protocol you need to have in terms of the technology. What have we found? A lot of these people who come up with new coins, where people put actual fiat currency into to buy. I mean, you can name these coins anything, people will still put money into it. I missed the whole trick there, I think. But yeah, so you have these coins, people create them, they create a hype behind them, and people put actual assets to buy these digital assets. And these assets are then based on the worst possible technical protocol that you have. No security, no proper infrastructure in place. Something falls apart, they're hackers, something happens, all the money disappears. Why? Because the law is technology neutral. Because there was no requirement that to be a bank or to be a coin that could be traded or something, that there was some minimum protection that you had to have a protocol that was secure, a protocol that had something that would help against malware or spyware or anything at all. And that's actually the problem that we're facing. Can it truly be technology neutral? Is this the correct principle to continue adhering to today? On the other hand, there is no good way forward, because if we keep following the technology, the law doesn't keep up. That's the truth. So we're kind of stuck between a rock and a really hard place in that sense, right? I mean, so what do? Do we base it on technology and technical protocols, or do we look at really technology neutral type principle based? And this project will actually look at that question, basically. So when we talk about applicable law, Do we really want to focus on a particular protocol, a particular technology? Can we do that? If not, so then why? And if you look at the UNIDROIT principles that were passed on the 12th of May of this year, they're completely neutral to the point that what they say digital assets comprise of is simply electronic records over which there is control exercised. Did you see the problem there? There is no technology mentioned in it at all. It really just is electronic records. Now, I understand why it was done that way. So it captures a group of digital assets that will not have to move with the technology. But there as well lies the issue, what is control? And can an AI have control over it? And if so, what happens there, for example? Now, we always talk about AI like this very bad, horrible tiger in the room, right? But if you think about it, if and when you decide to have children or the next generation, they probably would be, at least among this group of people, much more augmented users than you and I because of AI. So they would have this access, and if they will learn how to use AI properly. So I always think my children, for example, are going to be much better AI users than I am. They're going to be used to using this to scrape a lot of data and come to a conclusion quickly and to learn to differentiate between what is good and what is bad. Instead of becoming weaker, do we actually make users stronger? So are we protecting the correct party? So it's just basically, that's a very good point there in terms of technology neutrality. We adhere to it because that's what we have. But I suppose technology is like the technology neutrality, the principle is like democracy. It isn't ideal, but it's the best thing we have at the moment. So we keep to it.
Any more questions? If not, can I thank the very distinguished speaker sharing so much information and your insight. We don't get to sit to have a FaceTime with the experts from an international organization, HCCH, every day. So we very much appreciate this experience and your time. I also want to thank the audience today for braving the weather and come here to join us. Thank you very much. Have a very good afternoon, and we'll see you in the next event at IFO. Thank you.
Thank you very much. Thank you for having me.